Today we're tackling a topic that almost all of us have pretty strong feelings about: bad bosses. We've all had those really tough days at work, right? But when does a toxic workplace actually cross that line from just being, difficult to being legally actionable? We've dug deep into some rigorous legal analysis to separate the myths from the reality, and honestly, what we found is pretty surprising.
Okay, let's dive into this. Here is the big question. If your boss constantly humiliates you, can you actually sue them? Look, it's an incredibly common myth that being treated terribly at work automatically hands you the right to a massive lawsuit. So today, we're going to figure out exactly where the law draws its very uncompromising line between just having a terrible day at the office and actually having a winnable case in court. So here's our roadmap for today. We'll start with the bullying epidemic, introduce the IIED lifeline, break down the 4 elements of liability, compare extreme versus routine conduct, look at proving severe distress, and finally, we'll cover employer accountability.
Section 1. The workplace bullying epidemic. Because listen, if you've ever felt targeted in a high-pressure environment, I promise you, you are definitely not alone.
Just look at these numbers from a 2017 Workplace Bullying Institute survey. 19% of people in the U.S. report being directly targeted by workplace bullying, and another 19%? They've witnessed it firsthand. When you put that together, you're talking about nearly 40% of the entire U.S. workforce dealing with this kind of abusive behavior on a daily basis. To put that into perspective, that is literally millions of professionals navigating incredibly hostile environments just trying to do their jobs.
Now, what's really interesting about this next piece of data, and honestly pretty staggering, is this. 61% of workplace bullies are actually bosses. So we aren't just talking about peers squabbling at the water cooler. This is a top-down abuse of authority. It's coming directly from the person who controls your assignments, your paycheck, and your whole career trajectory. And that massive power imbalance is exactly what makes the situation so incredibly difficult to escape.
Clinically speaking, workplace bullying is defined as repeated, health-harming mistreatment or abusive conduct that leaves the victim feeling completely humiliated and threatened. And the human costs here are devastating. Victims systematically experience lower self-esteem, deep depression, and increased absenteeism. The psychological toll is very, very real. But that big question still remains. Is it actually illegal?
That brings us to Section 2, the IIED legal lifeline. Let's shift gears from the psychological problem to the actual legal solutions that are available to employees. If you're an at-will employee, which, let's face it, the vast majority of us are, your primary legal tool against severe bullying is a civil wrong known as the intentional infliction of emotional distress, or IIED for short. It essentially acts as the privatization of law enforcement. Think of it like this. When someone's behavior is completely unacceptable but doesn't quite trigger criminal law, like a physical assault would, IIED grants victims the power to sue that bad actor for compensatory damages. It really is a crucial lifeline for workers who feel like they have nowhere else to turn.
Moving on to Section 3, the 4 elements of liability. Let's move to and see how this builds, because having a legal lifeline is one thing, but the evidentiary hurdles to actually use it, they are incredibly high. To actually succeed in an IIED claim, a plaintiff has to prove 4 very specific elements. First, intentional or reckless conduct. Second, extreme and outrageous behavior. Third, a direct chain of causation. And fourth, severe distress. And let me be absolutely perfectly clear on this point. If you miss even one of these 4 steps, your entire case gets thrown right out of court. You need the whole shebang. Which brings us to Section 4, extreme versus routine conduct. This is where we really have to define what the law actually considers to be outrageous.
This direct comparison between failed and successful claims really tells you everything you need to know about the legal standard. On one side, we have the failed claims, mere insults, bad manners, rudeness, or even being humiliatingly demoted to shredding duties. Courts routinely view those as just the basic indignities of life. On the flip side, successful claims require utterly intolerable behavior. We are talking about physical or sexual abuse or extreme false accusations. For example, there was one cited case where a school principal publicly and falsely berated a teacher for illegal drug use while she was recovering from a suicide attempt. I mean, wow. That is the true, staggering level of outrage that the law actually requires.
Yeah, as jarring as it sounds, for minor insults, general rudeness, and insensitivity, the uncompromising nature of the law basically says, suck it up. The legal standard here is entirely objective.
It expects a reasonable and prudent person to just endure general bad manners and a tough boss without rushing to a judge. The law simply doesn't exist to police politeness.
However, context absolutely matters, and certain factors can push conduct over that legal line. A single insult usually fails, sure, but repeated, ongoing patterns of offense, that completely changes the dynamic. It's also taken much more seriously if the offender holds a position of power, like in the case of Hazant versus SkyWest Airlines, where supervisors subjected an employee to an ongoing pattern of sexual harassment and physical touching. That combination of direct authority and repeated abuse is exactly what makes the behavior legally actionable.
Okay, Section 5, proving severe emotional distress. So, the crucial point is that proving the conduct itself is terrible is really only half the battle. They made me think I was crazy. I literally thought maybe I was schizophrenic. They made me feel like I'm not even human. This was the direct testimony of a plaintiff, a nanny, who was subjected to immense psychological pressure to cover up child abuse she had witnessed. Reading that quote, it really anchors this kind of sterile legal theory in a devastating human reality. So the distress must be particularly acute. It has to extend far beyond just a passing upset, and it's always measured by that reasonable person standard. In the Grost MD case cited in the research, an employee experienced grief, wounded pride, and severe disappointment after being yelled at and excluded by her supervisor. Well, the court threw it out. General disappointment simply isn't enough. Winning requires serious, documentable anguish, often backed up by medical experts.
Finally, Section 6, holding employers legally accountable. When is the company itself actually forced to pay up for the sins of a rogue boss?
The legal doctrine at play here is called vicarious liability. Basically, under agency law, a company is held liable if the actions occur within the scope of employment and if the employee is attempting to further the employer's interests, even if they're doing it in a terrible way. But most importantly for workplace bullying, the company is on the hook if the employer authorizes or ratifies the conduct.
And this brilliantly illustrates that exact point, a major precedent involving Walmart. In this case, the employer knew a supervisor had done something completely atrocious, secretly filming an employee in a restroom and posting it online. But incredibly, they let that supervisor continue managing the victim. By turning a blind eye and failing to intervene, the company ratified the behavior, leaving themselves entirely legally exposed for the immense damage that was caused.
So what does this all mean for us? If your workplace is making you sick, is it just bad management, or have they actually crossed the line into outrageous liability? As we've seen, the bar for an IED claim is incredibly high. It's like a giant puzzle where every piece has to fit perfectly, and the law won't protect you from a boss who is, well, just a jerk. But when behavior crosses into the truly atrocious and the distress becomes catastrophic, there's a powerful, undeniable lifeline available to you. I really hope this explainer empowered you with a clear understanding of your legal boundaries.